Welcome to Still Unanswered. I'm Elena Marchetti. Tonight, we return to a case that has haunted courts, media rooms, and family living rooms for nearly 2 decades, the murder of Meredith Kercher, and the long, tangled legal and public aftermath that involved Amanda Knox, Raffaele Sollecito, and Rudy Guede. This episode is serious, reflective, and, I should warn you, somber. We're not here for lurid detail. We want to center Meredith and trace what remains unresolved. Daniel, thanks for joining me.
Thanks, Alina. It's good to be here. This case sits at the intersection of forensic practice, interrogation psychology, and media-driven narrative, all areas I study closely. I'm ready to walk through the facts and the failures with you.
Let's start at the beginning. Meredith Kercher. People sometimes file her into the margins of the story as a backdrop to the drama around Amanda. That's wrong. Meredith Susanna Cara Kercher was born December 28, 1985, in Croydon. She was a student, studious, loved languages, loved travel. She moved to Perugia in September 2007 to study at the University for Foreigners. She shared a cottage on Via della Pergola with Amanda Knox and 2 Italian women, Filomena Romanelli and Laura Mezzetti. She was 21.
Meredith was an ordinary young woman pursuing study abroad, which is worth stating because it frames everything else. Her family remembered her as responsible, close-knit, and creative. When we talk about failures in investigation and media, we shouldn't forget there's a real person at the center, with a family who wanted answers and dignity.
Exactly. The facts of the night, November 1st into the 2nd, 2007, are among the most contested. The short reconstruction. Meredith spent part of the evening with friends and later returned to the cottage. At some point, she was attacked in her bedroom and later found dead under a duvet with a severe stab wound to the neck and multiple injuries that forensic examiners interpreted as evidence of a violent assault. Neighbors reported hearing a scream around 11:30 p.m., though that's not definitive. Rudy Guede's DNA and a bloody handprint link him strongly to Meredith's room, but even that admission is complicated. Daniel, can you unpack how Guede became central?
Guede's presence is one of the clearer forensic threads. His DNA appeared inside Meredith's body, on her clothing, on a purse, and a bloody handprint matched him. He fled to Germany, was extradited, and in a fast-track trial was convicted, originally getting 30 years, later reduced to 16 on appeal under Italian procedures. Importantly, his conviction included a finding that he did not act alone. That notion, that Guedes wasn't alone, is what prosecutors later used to implicate Knox and Sollecito. But as we'll discuss, that tie, not alone, doesn't automatically prove collaboration with Knox and Raffaele.
That court decision, Guede's fast-track trial, and the finding he didn't act alone, became, in the English-language press especially, a kind of linchpin for the more sensational narratives. Meanwhile, Amanda Knox's conduct the morning the body was discovered and in the police station drew intense scrutiny. Let me be clear. Some of Knox's behavior was atypical. People kissed outside the house, she took a shower, she later sat with Sollecito. But behavior in grief is culturally inflected and sometimes baffling. The crucial moment I think we need to examine is the November 5-6 interrogation, when Knox was questioned intensely and eventually named Dia Patrick Lumumba. Daniel, take us through what's recorded about that interrogation.
This is where interrogation dynamics become central. Knox was a 20-year-old American with limited Italian. She says she was questioned for many hours, that there was no lawyer and no accredited interpreter present, and that she signed a typed Italian statement she later said she didn't fully understand. She later described the image of Patrick as a kind of intrusive thought, a vision that she felt compelled to repeat because of the pressure and exhaustion. There are allegations of verbal abuse, even a claim of being slapped on the head, though accounts vary. From what we know about the psychology of coerced or suggestible statements, a young person in those conditions can produce inaccurate, even false identifications.
Right. The consequence was immediate and brutal. Patrick Lumumba, a bar owner who had been working that night, was arrested and publicly vilified before a solid alibi emerged. He was later cleared and became an outspoken critic of how the system and the press treated him. There's a calumnia, slander, conviction hanging over Knox ever since. That's one of those unresolved moral knots. Even after the murder acquittal, Lumumba's life was deeply damaged.
We should pause on that. Legal responsibility for a false accusation depends on intent. Did Knox intentionally slander Lumumba? Or did she make a statement under coercion, confusion, and language barriers? Italian courts eventually convicted her for slander, and that part of her record remains tangled even after the Supreme Court cleared her of murder. Ethically, even if a statement is made under duress, an innocent person like Lumumba suffers real harm.
Let's move from the interrogation to the forensic claims that drove the prosecution's case. The kitchen knife, the bra clasp, luminol footprints, mixed DNA. For listeners who follow forensic debates, this is where the case really grinds. The prosecution put forward a sex game gone wrong narrative. Knox, Sollecito, and Guede allegedly together in Meredith's room, a sexual encounter, resistance, and violent escalation. That story appealed to sensational instincts. Daniel, how do you read the physical evidence the prosecution relied on?
When you separate rhetoric from reliable data, many of the prosecution's critical pieces have serious limitations. The knife seized from Sollecito's apartment had Knox's DNA on the handle. She'd cooked there, and a very small, low-quantity trace that analysts said could be Meredith's on the blade. But that trace was so small it risked contamination, and subsequent court-appointed experts in 2011 said the lab work didn't follow best practices. The bra clasp, found 46 days after the murder, was handled in ways that made contamination plausible. It later showed a profile prosecutors attributed to Sollecito, but the collection and storage chain was weak. Luminol reactions in the hallway suggested footprints, but luminol lights up for more than blood. Many common substances trigger it. So what looked like a forensic slam dunk often rested on shaky grounds.
And the appliance of those forensics to a narrative is part of what the Italian Supreme Court later called stunning flaws, a phrase that appears in their 2015 judgment overturning Knox and Sollecito's convictions. The court criticized the rush to judgment, the poor evidence handling, and the media pressure. But before we get to that reversal, we have to walk through the series of trials, multiple convictions and acquittals that left people outside Italy bewildered. Let's map that timeline succinctly. First trial conviction in 2009, appeal acquittal in 2011, prosecution appeals and a 2014 conviction in Florence, then the Supreme Court definitively overturned the conviction in 2015. Daniel, for listeners who come from common law systems, can you explain why these reversals happened and how the Italian appeal system works?
Italian procedure is different from the Anglo-American double jeopardy story. Appeals in Italy are often full retrials. The prosecution can appeal an acquittal. So the sequence you described, conviction, acquittal, retrial, reconviction, Supreme Court reversal, fits within Italian law. The 2011 acquittal centered heavily on forensic doubts. The 2014 reconviction hinged in part on different readings of evidence. Then the highest court in 2015 issued a written opinion that criticized the investigative mistakes and essentially said the evidence did not reliably prove Knox and Sollecito's involvement. That's when the legal record shifted. Innocence of the murder, but not necessarily a clean slate on other charges such as slander.
Listeners should not guilty and innocent in public language. The 2015 court used the word innocent in a way that echoed beyond Italian legal phrases. It was a rebuke. Still, many unanswered factual questions remained. Was Meredith attacked by one man, Guede, or by multiple people? Was the broken window a forced entry or staged? Did investigators contaminate the scene? These are the still unanswered pieces we promised to foreground tonight. Daniel, what do you think of the single attacker hypothesis versus the multi-perpetrator theory?
From a forensic psychological perspective, the presence of Guede's DNA inside the victim, on her clothing, the bloody handprint, is strong evidence he was involved in the assault. The argument for additional perpetrators typically rests on the idea that the level of violence and signs of attempted restraint imply more than one assailant. But that's inferential. If the physical traces of other people are absent or minimal, the simplest explanation might be that Guede acted alone. Then again, absence of evidence is not always evidence of absence. Poor scene handling, contamination, and delays in collection could erase traces. That uncertainty is where science and investigation collided in this case.
And that collision was worsened by early mistakes. People walking through the cottage, the way items were photographed and collected, even how a bra clasp was moved. For true crime listeners who care about methodology, contamination risk skyrockets when a scene isn't sealed and when evidence is handled without strict chain of custody protocols. In Perugia, during those first chaotic hours and days, that's exactly what happened. Daniel, you study wrongful convictions. When you see errors like this paired with intense public pressure, what tends to happen to decision-making in criminal cases?
Pressure breeds tunnel vision. Investigators, prosecutors, and even judges can develop a narrative early and then look for evidence to fit it. Cognitive biases, confirmation bias, availability cascades, amplified by media frenzy, make contradictory information harder to integrate. In the Knox case, a dramatic narrative, sexualized, foreign, and scandalous, gained traction in the press, which in turn made a quick resolution desirable for authorities. Once certain interpretations of behavior and minor forensic clues were framed as telling signs, they disproportionately influenced decisions. That's not to say investigators were malicious. Often they're overworked and under-resourced. But the system is vulnerable when checks and independent reviews are weak.
You used the word sexualized, and I want to expand on that. The tabloid nickname Foxy Knoxy and the focus on Amanda's sexuality and behavior are deeply gendered. The media coverage turned a young American woman into a caricature, sometimes more than they discussed Meredith, and that skewed public empathy. The Kercher family frequently complained that Meredith became background static to a spectacle about Knox. That's a moral problem for journalism. Daniel, how does that gendered framing affect juries and public opinion?
It matters a great deal. Stereotypes about female sexuality, the temptress archetype, or conversely the pure victim ideal, shape how people interpret ambiguous behavior. When press narratives emphasize a defendant's sex life, dress, or perceived promiscuity, it can prime jurors and laypeople to see guilt as plausible. That's especially dangerous when the forensic evidence is ambiguous. The Knox case is a textbook example of how media framing can spin a narrative that then interacts with investigative bias to produce an outcome that feels coherent to the public, even if it's not supported by robust science.
Let's talk about the human costs. Meredith is gone. Her family held a funeral in December 2007 and later set up a scholarship in her name. Amanda Knox served time, then returned to the U.S., wrote a memoir, became a public advocate on wrongful conviction topics, but she still carries the slender conviction and pervasive stigma. Patrick Lumumba lost months behind bars and his reputation, and his life was never quite the same. Rudy Gued served time and was released in November 2021. Questions about his role and remorse linger. Raffaele Sollecito returned to Italy, wrote a memoir, and tried to rebuild his life. There are no clean endings here.
That's the most painful part psychologically. Each person carries trauma of different kinds. Meredith's family lost a daughter. Amanda endured imprisonment and public vilification. Lumumba lost years and reputation. Sollecito lost years. Gued has served time but still leaves many questions. The legal system can produce multiple kinds of harm simultaneously. The public sometimes wants a single, satisfying resolution, a villain, a confession, a neatly tied verdict. But messy reality rarely delivers that.
There are also tangible procedural lessons. The 2011 appellate experts, court-appointed, were critical in undermining the knife and bra clasp evidence. They found lab work that didn't adhere to best practices and concluded the low-level DNA results were unreliable. The Supreme Court then used language about stunning flaws. Daniel, from your perspective, what should investigators and courts take away from those expert critiques?
3 things. First, independent, transparent forensic review is essential. Courts should not simply accept police lab results without scrutiny. Second, chain of custody and scene protocols matter. They are not bureaucratic details. They are what preserve the truth. Third, when evidence is low copy number DNA, tiny traces, courts must acknowledge the contamination risk and treat such results with caution, not as definitive proof. Forensic humility is necessary. Experts must communicate uncertainty clearly to judges and juries.
Let's address the contested pieces directly: the broken window, the staged burglary, and the question of motive. The broken window in Filomena's room was used early to suggest staging. Shards rested on top of belongings, shutters closed, inconsistent with an exterior break-in. Some analysts later argued a break-in was plausible. Is it fair to say the physical reconstruction never reached consensus?
Fair. Some reconstruction specialists thought the distribution of glass and the shutter position suggested internal breakage, staged. Others thought an outside-in entry could still be possible depending on the dynamics. Crime scene reconstruction is an interpretive science. It requires reliable measurements and careful modeling. In a chaotic, contaminated scene with delayed, inconsistent documentation, interpretive gaps widen. That absence of consensus should have pushed investigators to be more tentative in their public narratives.
We also need to acknowledge the cultural and procedural differences in law. The Italian appeals system allows retrials. Prosecutions can and did appeal acquittals. For many Americans, it felt like double jeopardy. But in Italy, it's a normal process. The chaos in public perception was partly because domestic legal norms differ, and the press didn't always clarify that. Daniel, how do courts balance the public's desire for certainty with the legal system's iterative nature?
Courts can't control the public's appetite for clarity, but they can help by communicating process and rationale transparently. Transparent written opinions explaining why evidence was accepted or rejected, why a retrial is warranted, and what procedural norms apply can help. But the reality is that high-profile cases are political as well as legal. Once a narrative takes hold in the press, it's nearly impossible to fully depoliticize legal proceedings.
We promised to highlight what still remains unanswered. I list the major holes and then let's parse them. 1. The exact number of attackers and whether Guede acted alone. 2. The motive. 3. Whether the broken window was genuine or staged. 4. The precise conduct of the interrogation that produced the Lumbumba accusation. 5. The role of media in biasing the process. And 6. What restitution for Lumbumba would actually look like. Start with the hardest, number of attackers. Daniel.
The evidence points strongly to Guede being present and directly involved. Beyond that, the forensic record does not robustly implicate other parties. Court findings at different times asserted not alone, but those relied on inferential readings rather than direct biological proof. Without clear DNA, hair, or fingerprints of additional perpetrators preserved in a reliable way, a single attacker scenario remains plausible. That said, if one accepts the not alone wording at face value, then a full re-examination of Guede's statements, his whereabouts in detail, and any corroborative evidence would be needed. And I'm not convinced that's been exhaustively done in a way that convinces everyone.
Motive follows from that. If it was a burglary that turned violent when Meredith encountered an intruder, a sadly plausible explanation, that's quite different from a group sexualized attack. One reason the prosecution settled on a sexualized sex game gone wrong narrative was cultural. It fit the sensational appetite. But the forensic facts point more toward a violent break-in or a single perpetrator who escalated. Daniel, what do you make of Guede's own statements, inconsistent over time, sometimes suggesting others were present, but also claiming panic and flight?
Guede's statements have shifted. He admitted being at the cottage and having sexual contact with Meredith earlier in the evening. He claimed he was in the bathroom when an unidentified assailant attacked her, then fled. These are classic patterns in self-protective narratives, partial admission paired with deflection. Courts convicted him. Whether his initial claim that he was not alone should be credited is subject to scrutiny. One must weigh the biological evidence, his behavior, and the possibility of him shifting responsibility. His claims alone are not dispositive.
Let's touch on the slander question once more. In June 2024, a Florence court reconvicted Knox for slander. In January 2025, the Italian Supreme Court upheld that conviction. So even with the murder exoneration, the record keeps a stain. Daniel, from a psychological and ethical standpoint, how should we think about statements made under duress that cause concrete harm?
We need a middle path. Legal systems should acknowledge human frailty under coercive interrogation and protect vulnerable people with clear procedural safeguards, access to counsel, accredited interpreters, recorded interviews. At the same time, when someone's statements cause severe harm to an innocent third party, like Lumumba, there should be mechanisms for restitution, apology, or remediation that are meaningful. Criminal liability, which requires proof of intent, is a blunt instrument for situations where intent is absent or ambiguous. Societies must find restorative paths that address victims' harms without unjustly punishing people traumatized by interrogation.
That restorative idea is crucial. Many commentators have asked, what would genuine restitution for Lumumba look like? Monetary compensation is part of it, but so is public apology, clearing of reputation, and structural changes to prevent future wrongful arrests. The legal system can offer civil remedies, and media organizations can do more to correct the record. But a public memory, once damaged, is hard to repair.
True. Repair is never perfect. Rehabilitation of reputation requires sustained action. Public acknowledgments by officials who misled, financial compensation where appropriate, and media accountability. Importantly, structural changes, mandatory recording of interrogations, interpreter access, forensic lab accreditation can prevent recurrence.
Before we move to close, I want to address the families. Meredith's family has repeatedly said they feel the focus on Amanda overshadowed Meredith's memory. They want clarity and, more than anything perhaps, an end to speculation. Amanda Knox has spoken about PTSD, nightmares, and what she calls a new kind of prison, the ongoing public scrutiny. Rudy Guede has been released and tries to reintegrate. Raffaele Sollecito rebuilt parts of his life. None of these evolutions erase the fundamental loss at the center, Meredith's life.
That's right. Cases like this demand a kind of dual empathy for the victim and their family, and for the people who may have been wrongfully convicted or harmed by the system. Empathy doesn't mean equal moral weight in every claim, but it means resisting the tabloids' appetite for villains and instead holding institutions accountable.
We're approaching the end of our time. I want to offer listeners some concrete takeaways and actions. First, hold forensic evidence to scientific standards. Small, low-copy DNA results require cautious interpretation. Second, demand recorded interviews, certified interpreters, and prompt access to counsel for non-native speakers. Third, journalists should refrain from character-driven sensationalism and focus on victims and factual reporting. Fourth, if you're moved by Meredith's story, consider supporting scholarships and memorials set up in her name, or organizations working on forensic reforms. Daniel, final words.
We must treat forensic uncertainty with humility. Systems must build guardrails to prevent tunnel vision, and civil society must push for transparency, from police to labs to courts. Above all, remember that behind every sensational headline is a human life. Justice isn't about satisfying public hunger for drama. It's about truth, accountability, and repair.
Thank you, Daniel. For those who want to dig deeper, we'll include reading and source notes in the episode description. Britannica, The Guardian timelines, court documents, and the 2011 forensic reviews. Our aim is not to close the case definitively tonight. It's to map the uncertainties and the structural failures and to center Meredith's memory in a debate that often sidelines her. Daniel, one last quick question. If you could ask one thing of future investigators on cases like this, what would it be?
Record everything. Not just for accountability, but because memory is fragile and pressure distorts recollection. When you have a full record, you can revisit choices, test hypotheses, and correct mistakes. It's simple and powerful.
Record everything. Simple, powerful. To our listeners, thank you for joining us for Still Unanswered. This case remains a mirror for broader questions about justice, memory, and media. We'll be back with more episodes that try to bring clarity where uncertainty and hurt remain. If you found this episode meaningful, please consider subscribing and reading our source material. And, if you can, support organizations that protect victims and improve forensic standards. Good night, and hold the victims in your mind when the headlines fade.
Good night.